Okay, you should. Good afternoon. I'm going to ask our court reporter. Hey, Samantha, how are you?
Good, thank you.
Good. I'm going to ask our court reporter if she can go ahead and begin taking this matter down and let me call it. This is John Wood, Grieved Elector versus Secretary of State Brad Raffensperger and Governor Brian Kemp. And this is 2020 CV342959. Again, I'm going to ask us to do some introductions in just a moment, but I will start off by saying that today is Monday, December the 7th, 2020. I am in courtroom 8A. Our courtroom is open to the public, staffed by a member of the Sheriff's Department, and therefore we have satisfied our very solemn obligation to keep the public's business open and accessible to it. Also, put this matter enabled our YouTube live stream video function, which is accessible through our court link to have this further publicly available. And that, again, satisfies that obligation, which we take very seriously. Everyone else appears via the Zoom teleconference platform. We've tried to make that link available to those whom we knew were involved. And all I ask, I think we're all pretty accustomed to it now, all I ask is that you just mute if you're not speaking. I do have the proceedings on our big monitor in the event anybody comes in, but I'm not seeing anybody. And therefore, in view of the fact that the safe distance from the deputy, I am not wearing a mask, and she can remove her mask if she would like. And I'm assuming that all of you, wherever you are in your offices or other places, are similarly being safe. So with that, I think the most important thing for me is just to get a little bit organized, because there's been a lot of paper flying around in the last several days. Let me tell you what I see on the docket, and I'm going to propose a way to move forward. And to the extent that you disagree with it, you can raise your hands and I will recognize you. The petition was filed on November the 25th, which, and I'm not saying this in any way other than it was the day before Thanksgiving. So the court was closed on Thanksgiving and the day after Thanksgiving. We became aware first of the motion to intervene on behalf of what I will call the Biden electors, unless you're using some other name for reference, but the motion to intervene and then the emergency relief requested on behalf of the Biden electors. So my proposal would be to start there. There are also motions to intervene by Sean, and I'm going to go with Drame. I don't know if he or any, oh, that's right. Hey, Mr. Harding, this is Jane Barwick. How are you?
Hey, Judge, how are you? It's Drame.
Drame, okay.
Yes, ma'am.
There was a motion to intervene filed on behalf of Sean Drame, and a motion to intervene filed on behalf of the NAACP and others, Georgia Coalition for the People's Agenda, James Woodall, and Helen Butler. I think those are the more recent in time. So, and then there's been a motion to exclude the petitioner's expert, and I believe that was filed by the Biden electors. Is that right?
That's correct, Your Honor.
Ms. Lewis? Okay. So my proposal is that, and again, I'm happy to consider something else. is that we go motion to intervene on behalf of the Biden electors, and take that up first. Now, I would like to do some introductions. I know we also have some attorneys who've sought admission pro hoc, and I printed that out and then forgot to take it off my printer, but so we can address that as well. But you want to, Mr. Harding, you want to go first? You're just on by way of introduction.
Todd Harding, my office is in Griffin, Georgia, and represent Mr. Wood and file the motion to intervene on behalf of Mr. Drame.
Okay.
I'm fine with starting with the interveners and the, I guess we move into the pro-hack issues after that. But as far as the motion to exclude, we weren't able to get Mr. Brainerd available today. So I'd ask for that to maybe be heard right before the evidentiary hearing, or if the court's going to allow them to file motions to dismiss after they're made a party at the same time as those.
Okay. All right. Well, it's nice to meet you. Welcome.
You too.
Okay. Who wants to go next? Mr. Willard, welcome. You're on mute.
Sorry, Your Honor, I thought the court had put me on mute and had taken me off. Russ Willard from the Attorney General's office. I'm here representing Governor Kemp and Secretary Raffensperger.
Okay. Thank you. Welcome. Okay. Ms. Gist-Lewis, why don't you go next?
Good afternoon, Your Honor. Joyce Gist-Lewis of Crumlin and Horst here representing the Biden electors. With me is Kevin Hamilton of Perkins Coie, and Mr. Hamilton has, we believe, met all of the requirements to be admitted pro hoc vice, and we would propose to have him handle argument on the motion to intervene, and if the court chooses to entertain it today, on the motion to exclude.
Motion to exclude. Okay. And Mr. Cardall?
I'm with Mr. Harding, and I'm proposed motion for pro hoc vice has been or is going to be submitted. I don't know if it's complete. I was told it was going to be filed. I think, Todd, you mentioned it was.
Okay. Well, let me ask this. Maybe this is the better question, but if you know, y'all tell me. With regard to the application, since we do have people on, I think with the exception of the defendants, on all sides, do we have a problem with the pro-hack applicants going ahead and speaking today? Mr. Harding?
No objection to that, Your Honor.
Okay, Mr. Willard?
No objection, Your Honor.
And Ms. Gist-Lewis?
No objection, Your Honor.
Okay. Now, unless I have mismanaged my technology, you are the only ones I'm seeing on the screen. I don't know if there are a bunch of other folks or not, but I cannot see them. So, Ms. Gist-Lewis, I hear you saying that Mr. Hamilton is going to argue?
Yes, Your Honor.
Okay. Mr. Hamilton, would you like to proceed?
Thank you, Your Honor. As I understand it, the matter you'd like to address first is the intervention motion. Is that right?
Yes.
Okay, thank you. As you mentioned, Your Honor, the defendant interveners are the Biden electors who prevailed in the November 3rd presidential election in Georgia. They've now been certified by Georgia's Secretary of State and Governor to appear and cast their votes on behalf of the state of Georgia when the Electoral College meets on December 14 for the purpose of selecting a president of the United States. This contest litigation seeks to challenge and overturn that election and replace the certified state slate of Biden electors with an alternative slate of Trump electors. And so the Biden electors seek to intervene in this litigation as defendants for the purpose of defending their own election as electors. And I would submit that the motion should be granted for three reasons. First, the Biden electors have a statutory right to intervene. Georgia law requires that when an election contest is filed, it must name as the defendant, quote, the person whose election is contested, close quote. And that's OCGA 21-2-522A.
Let me stop you for just 1 second for a question, Mr. Hamilton. All right, the Adam Sparks affidavit, which is attached to, I don't know what it is. The motion to exclude, but the Adam Sparks affidavit adds, now I may be looking at the wrong thing. There's something puts before the court the certification by the governor. And is that what you're, I just want some reference to what's before me now with regard to what exactly you're referring to. You said certified by the Georgia governor and the Secretary of State.
That's correct. The governor, and I'm sure Mr. Willard might be able to do this even better than me, but the Secretary of State certifies the election totals and under Georgia law lays them before the governor. The governor then signs a certificate of ascertainment. It's not a certificate of an election. That's delivered to the archivist of the United States. And that's the mechanics by which the electors are selected. And in this, and both of those things have happened. Now, of course, Georgia has gone through not one, but two different recounts, with the final one being completed just this morning. But there is a completed certificate of ascertainment that will be updated today. But that is the document that is at issue here in this election contest. And what the plaintiffs seek to do is to contest the election of the Biden electors. And under the statute, they have to name those electors. They have to name the person whose election is contested. And as you know, Your Honor, presidential candidates are not directly elected by the voters of Georgia or any other state in the union. Instead, Georgia's voters select presidential electors who then vote for the presidential candidates on their behalf at the meeting of the Electoral College. So the proper defendants in this action are and always were the Biden electors, who should have been named as defendants in the first instance, since that is the election that is at issue here. And as a result, the Biden electors have a statutory right to intervene in the litigation under OCGA 9-11-24A1. Georgia law permits intervention as a matter of right when the statute confers an unconditional right to intervene. So that's the first reason. Second reason would be even if the Biden electors didn't have an explicit statutory right to intervene, they should be allowed intervention as of right under 9-11-24A2, which allows anyone shall be permitted to intervene in an action when the applicant claims an interest relating to the subject matter of the action, and the applicant is so situated that the disposition of the action may, as a practical matter, impair or impede his or her ability to protect that interest unless the applicant's interest is adequately represented by the existing party. I'm sure the court is familiar with that, the rule. Georgia courts describe it as a three-part test. Do you have an interest? Is there a potential impairment if an unfavorable disposition of the case is rendered? And is there inadequate representation of that interest? The Biden electors easily meet all three requirements. First, they obviously have a direct interest in defending the certification of their own electoral victory from attack in this case. The lawsuit can hardly be called anything but a clear, direct, and obvious challenge to their election. So the interest element is met. Second, an adverse ruling in the litigation would obviously impair that interest if the relief sought is granted. Mr. Wood asked the court to rescind the certification of an election that's already been certified. It's difficult to imagine a more clear impairment. And finally, the Biden electors' interests can't be adequately represented by the state defendants who are not proper defendants to begin with. And to the extent they even remain parties in the litigation, their interests lie only in defending the state and its officers' execution of the statutory duties. And third and finally, even if the court were to find that the Biden electors don't have a right to intervene as a matter of right, they should be allowed permissive intervention under OCGA 9-11-24B2. The court, as I'm sure you are aware, Georgia law allows permissive intervention when a claim or defense and the main action have a question of law or fact in common, so long as it won't delay the proceedings or prejudice the rights of the original parties. Obviously, there are common questions of law and fact here, since the whole point of the litigation is the election and certification of the Biden electors. And there's been no delay in filing the motion, and substituting the proper parties, the proper defendants, can hardly be said to prejudice the rights. And I'll just mention that this morning, Judge Richardson, in a different election contest, heard the same motion and granted intervention. Obviously, that's not controlling on Your Honor, but I do think it is persuasive. And for all those reasons, I'd submit that the Biden electors should be admitted, allowed to intervene in this action as intervener defendants.
Okay, I'm going to let Mr. Harding respond, but what does that do to us today, Mr. Hamilton?
Nothing, Your Honor. We're prepared to argue the case on the merits. I believe that what you have before you is a motion to dismiss as well as a motion to exclude the experts. And what I would hope and what I would propose is, after we address the motion for intervention, that we turn to the motion to dismiss. There is a strong interest in resolving the ambiguity and uncertainty prior to the expiration of the Safe Harbor Act, the Safe Harbor deadline, which is the end of the day tomorrow, December 8th. And so, this court has already noted this case for hearing today. The parties are before you today. I had, at least it was my understanding that the case was to be heard on the merits today. But in any event, the motion to dismiss is before you. We filed that quite a while ago, and I would ask the court to either entertain argument on that motion today, so that the court would be in a position to fully and finally adjudicate the dispute, or as Judge Richardson did in the Bolin case, require a response to the motion to dismiss and set it for a hearing tomorrow, so as to allow a decision on the merits before the Safe Harbor deadline passes.
Okay. All right, Mr. Harding, would you like to respond?
We don't have an objection to them being added, Your Honor. We would just ask if the court adds them to give us an opportunity to amend, to adjust our relief sought pursuant to the election contest statutes. And with regard to we're not prepared to argue the motion to dismiss today or the motion to exclude. I think Mr. Hamilton's idea of allowing us, after the intervention is granted, to respond to it, have it heard tomorrow, would be acceptable.
Okay. All right. And as far as the motions to intervene on behalf of Mr. Drame, NAACP, the Georgia Coalition for People's Agenda, and the two individuals, do we need to discuss those? Those are pretty recent, but.
We have no objection to any of those, Your Honor.
All right. Mr. Hamilton.
If we're allowed to intervene, Your Honor, we have no objection to the intervention motions of the other parties.
That makes sense. Mr. Willard, any position?
Your Honor, in terms of the intervention by the presidential electors, the state has no objection to the intervention. In regards to the other intervention, I have not been provided a copy of their motion to intervene or any of the pleadings thereto, and I'm not sure what standing they're asserting for coming in. I'd like the opportunity to review that before the state takes a position on whether the second group of interveners should be allowed to intervene.
Okay. Well, at this point, let's go ahead and argue the Biden electors, and without making a ruling, what I'd like to do is go ahead and hear the Biden electors' motion to dismiss. And I understand Mr. Harding said he's not necessarily ready to do that, but that was filed last week. We've had as much time on that as anything. And at this point, I'd like for you to go ahead on that.
Your Honor, if I could I raise a housekeeping issue before we proceed any further?
Yes.
Before we get too far down this road, Your Honor, and I'm sorry, the governor was served last week. The secretary, I believe, was not served until Friday. We've been sort of scrambling, as you may have read. We've had a number of emergency petitions filed in federal court that we've been responding to along with a federal appellate briefing. But at the outset, the plaintiffs have named the governor and the secretary of state as defendants to this action. Before we go any further, I think the court needs to inquire into whether they are in fact proper defendants. 21.2.5, I'm sorry, let me pull the statute back up. I flipped off of it while we were discussing other issues. 522 defines who is a defendant for an election contest. It gives 4 potential categories of defendants. None of those categories encompass either the Georgia Secretary of State or the governor of the state of Georgia. As such, they should be dismissed from this lawsuit, and the action should proceed with the plaintiffs and the intervener defendants.
Okay, well, let me clarify a couple of things. Number one, I haven't ruled on the motions to intervene. I'm hearing argument now with everything, as it were, thus far under advisement. So that's number one. Number two, if the court were here, and have asked for argument on that, so let's assume that I'm going to hear the motion to dismiss on behalf of the Biden electors. If I hear that, would that not potentially take care of the whole case? In other words, if the Biden electors or intervenors, their parties, I hear their motion to dismiss, would that not potentially take care, if that goes the way that I don't know how it's going to go, would that not potentially dismiss the whole case?
It would resolve the case, Your Honor, but I'm just saying that the governor and the secretary, as Judge Grubbs found back in 2019 in the election contest versus the lieutenant governor that was taken up on appeal, the secretary of state, nor in this case the governor, are appropriate parties for an election contest under 21.2.500 et sec. And the merits can be raised and argued between the plaintiffs and the intervener defendants. We have no issue with that going forward. We are saying at this point, though, there is no reason to carry the secretary of state and the governor along for the ride in that regards.
So essentially, this is an oral motion to dismiss on behalf of the governor and the secretary.
That's correct, Your Honor. There is no authority in the Georgia Code for them to be defendants in an election contest, especially one as envisioned by the plaintiffs.
So if that were the case, there'd be nothing to intervene into.
That's correct, Your Honor, if you have not actually ruled on the intervention motion at this point.
Remember, I said I took it under advisement. So if I were to, well, we'd have to argue your motion, but if the governor and the secretary of state are not the proper parties to bring this case against, and there's nobody else, the case would then be concluded.
That's correct, Your Honor.
And your argument, Mr. Willard, is that under the statutory authority of 522 of the categories of potential respondents, the governor and the secretary aren't in there.
That's correct, Your Honor. The 522 defines defendant as either the person whose nomination or election is contested, the person or person whose eligibility to seek any nomination or office in a runoff or primary or election is contested, the election superintendent or superintendents who conducted the contested primary election, or the public officer who formally declared the number of votes for and against any question submitted to electors at any election. And Your Honor should also be aware that election superintendent is defined in the Georgia Code in a way that makes clear that the secretary is not an election superintendent either. Under 21-2-235, superintendent is defined as the judge of the probate court of a county or the county board of elections, the county board of elections and registration, the joint city county board of elections, or the joint city county board of elections and registration if a county has such.
Okay. Mr. Willard, 21-2-522 you're saying that's where I find potential.
I'm sorry, and the General Assembly sometimes alters their numbering nomenclature. It is 21-2-520 parens 2.
Okay.
520, and then underneath 520 is parens 2.
Got it. Also helpful for the court reporter. All right, person whose nomination or election. So defendant means A, and I'm reading from 21-2-520, and this is subparagraph or paragraph 2. Defendant means A, the person whose nomination or election is contested, not the governor or the secretary of state, right?
Correct.
B, the person or persons whose eligibility to seek any nomination or office in a runoff primary or election is contested. Not the case here. C, the election superintendent who conducted the contested election, and you're saying by case law that is not the Secretary of State.
Correct, Your Honor. And in addition, it is not as the General Assembly has defined it. Once again, we're going to have one of those where they didn't use alpha designations before they started numbering, but it's 21-2-2 parens 35. At that point, the General Assembly has defined the term superintendent for Chapter 2 of Article 21, Title 21.
Okay, so not case law, but statutory law.
I referred also to the case law. That is the Martin litigation that took place following the 2018 election, where there was an election test not filed by the Democratic candidate for lieutenant governor, but filed on her behalf, that was litigated in front of Adele Grubb, sitting by designation in Fulton County, where she likewise found that Title 21, Chapter 2 of Title 21 does not define superintendent to include the Secretary of State and dismiss the Secretary of State as a defendant. That case went up on appeal. I can give you the cite from the Georgia Supreme Court, their decision that came out last October of 2019. That is 307 Georgia 193, that approvingly upholds Judge Grubb's decisions in that case. The only thing that they differed with her on was she apparently made a factual statement in regards to one of her findings of fact that was unsupported by anything that they could find in the record. But they affirmed under the right for any reason rule, which included, among other things, the dismissal of the Secretary of State as a defendant in the action.
Okay, and then finally, under 21-2-520, paragraph 2, subparagraph D, the public officer who formally declared the number of votes for and against any question submitted to electors at an election.
Correct, Your Honor. And there is no challenge, as far as I'm aware, to either of the two constitutional amendment questions that were submitted to the voters, or I believe there was also a ad valorem taxation issue that was submitted to the voters, but those were the only 3 questions that were submitted to the voters statewide.
Okay, and before I go to Mr. Harding for a response, what about the claims for equitable relief? The petitioners have come to Superior Court and stated that for constitutional reasons, something should happen, which is not necessarily characterized under our election code. What is your response to that? This court has equitable authority.
It does if a case is properly before it, but they have brought their challenge. Their relief is equitable in nature, but they're bringing their challenge as an election contest, and all the relief is contingent thereon.
As an approved elector. Okay.
Right. In addition, they have to establish that they have the ability to bring an action for equitable relief against these state defendants sued in their official capacity. And it's my understanding that they have not pointed to any express allowance of authority for bringing such an action against the state defendants in their official capacity.
Okay. All right. Mr. Harding, would you like to respond?
Yes, Judge. We are seeking relief against the governor and the secretary. As you know, under 21, I believe it's 2499, paragraph B, the secretary has to certify the results, and then the governor, on the 18th day after the election, has to certify the electors to the person with the most, or the candidate with the most votes. So if you're challenging the election and saying there are illegal votes, I think by definition, you have to seek relief against them, because the only one who can decertify that would be the secretary and the governor. And I think that would start placing some federal law, the electoral, I think it's the Electoral Count Act of 1877, on whose electors would be counted, or if any electors would be counted, based upon the process laid out in, I think it's 3 USC section 15, how they actually count them. So they may be certified, but if the court had an evidentiary hearing and found this case invalid, or found the election to be invalid, they would need to be decertified so they wouldn't be counted. And I think the only person who could do that would be the governor or the secretary of state.
Can the governor, secretary of state, let's say I issue an injunction along the lines requested, do they have, pretermitting my authority to do that, do they have the ability to uncertify, or as you say, decertify? Because this kind of falls in and I'm using it only as not authority, but I'm using it only, let me just use the word of interest, but we have Judge Pryor's order essentially holding that relief, I think, and much smarter people can tell me the import of that case, but essentially is moot. How do I order somebody to decertify, and can I order somebody to do something not doable?
Yeah, I think under 21.2525 at paragraph B, the court has plenary power, which is absolute power to enforce. It's let me see, I got it right here. Make, issue, enforce all necessary orders, rules, processes, and decrees for full and proper understanding and final determination and enforcement of the decision of every case. So I think if the court found that the election was invalid, or I think the term used in the USC's failed election, I think you could order that to be part of the remedy. And I think that's who would have to be sought against.
Okay, so I think I'm hearing your argument against Mr. Willard's position to be, but there's other relief sought than that of 21-2-520.
Correct.
And that is equitable.
Yes.
All right, I'm going to hold that. I'm going to take that under advisement.
Your Honor,
Yes.
like I said at the outset, and I don't think it was addressed by plaintiff's counsel, it is incumbent upon the plaintiffs to find a waiver of the immunities enjoyed by state officials in order to bring an action. They have not identified one as of yet, which is a fatal defect to any claims that they have outside of the claims under 21-520 et sec, which
I'm sorry.
belief in the election
I'm
contest.
sorry, Mr. Willard.
Their claims are subject to dismissal.
Ms. Willard, hang on. The court reporter just didn't hear something you said. Go back to the last thing, Samantha, please.
He could just repeat the last thing he was saying in the last thing you were saying, sir.
All right, not sure where I broke off, and it wasn't that long. I'll just reiterate it. It is incumbent upon the plaintiffs to find a waiver in order to bring claims and seek relief against government officials. They have failed to articulate any waiver of the immunities enjoyed by the government officials against relief sought against them, including equitable relief. As such, that is a fatal defect in their complaint, that in addition to failing to fit within the definition of defendants under 21-520 parens 2 is fatal to their complaint and subjects their complaint to dismissal. It is not incumbent upon me to point to any waiver that would permit claims. It is incumbent upon the plaintiffs to establish a waiver. They have failed to do so for any of their claims, including those for equitable relief.
Okay, so let me tell you what I just heard, and let's see if I heard the right thing. So now you're saying that unless they can fall under the statutory authority of 21-2-520 or other statutory election provision, that there's a sovereign immunity bar.
That's correct, Your Honor.
Okay. All right, I will take that under advisement. Now, may I hear from either Mr. Hamilton or Ms. Gist-Lewis on the motion to dismiss under the Biden electors' motion to intervene, if granted?
Thank you, Your Honor. Yes, I'd be happy to address that. Your Honor, on November 3rd, the voters of Georgia and the nation as a whole elected Joe Biden as president of the United States. The margin in the state of Georgia was over 12,000 votes. As we've just been discussing, those votes were carefully canvassed, audited, recounted, and then recounted again, and certified by county and state officials. 3 full weeks after that election, on November 25th, Mr. Wood filed this statutory election contest. He seeks breathtaking relief, an order from this court overturning the election and requiring the governor to certify whatever presidential electors might be appointed at some undetermined time by the Georgia General Assembly. Or in the alternative, asking this court to annul the November 3rd election and mandate a whole new election at some future time. The first remedy would entirely silence the voice of nearly 5 million Georgia voters in the selection of the president of the United States. And the second would disenfranchise those same 5 million voters and force them to participate in an unconstitutional do-over election in plain violation of federal law. Honestly, it's difficult to imagine a more shocking and fundamentally undemocratic act than asking a court to overturn the express will of the entire state of Georgia, simply because Mr. Wood's preferred candidate didn't win the election.
I don't think the will of the entire state of Georgia.
Well, fair enough.
The
majority of the state of Georgia, the express will of the majority. That's how the state of Georgia expresses its will in a democratic election, and the majority controls. Your Honor, no court in American history has ever entered the relief that plaintiff seeks here. And one would imagine that if approaching this court, the contestant who seeks such breathtaking relief would come armed with some formidable showing. The United States District Court for the Middle District of Pennsylvania noted just 2 weeks ago, one might expect you'd come formidably armed with compelling legal arguments and factual proof of rampant corruption, such that the court would have no option but to regrettably grant the proposed relief despite the impact it would have on such a large group of contestants. Not Mr. Wood. It's difficult to imagine that even he takes this claim seriously. It appears to be nothing more than an effort to disparage state and county election officials across the country, all in service of some larger agenda. The claims that are presented here do not warrant the relief Mr. Wood seeks. In Georgia, these same claims have been made, considered, and definitively rejected by state and federal courts, including claims brought by Mr. Wood himself. Mr. Wood brought an action in Georgia Voters Alliance versus Raffensperger, alleging the same claims relating to the Center for Technology and Civil Life grants at issue here. It was rejected by that court. Plaintiff Lynn Wood brought a challenge to the settlement agreement, also challenged by the contestant before you today, John Wood, in a different federal lawsuit. That's Wood versus Raffensperger. That claim was decisively rejected by Judge Grinberg. Just last Friday, that dismissal was affirmed by the 11th Circuit in an order sharply critical of the claim. So both of the claims before you, Your Honor, the CTCL grants and the settlement agreement challenge, have been brought, considered, and rejected. So I would submit that the court should do the same. The claims are barred by latches. They fall outside the Georgia election contest statute, and in any event, fail to state a claim for which relief might be granted. But even if the court were to consider the contest on the merits, the closer the one examines the claims and the supposed supporting evidence, the more the case simply falls apart. The evidence before you is nothing more than speculation, conspiracy theories, and a fundamental misunderstanding of the electoral process in Georgia. And finally, and this is the point that you've just been discussing, the relief sought cannot be granted. And it's interesting that two different federal courts in two different states this very morning have reached that conclusion. Federal District Court in Michigan this morning dismissing a similar sort of case, seeking an unconstitutional do-over election, said, I can't give you the relief that you seek. And then again this morning, Federal District Court here in Georgia reached the same conclusion. I would submit that this court has no more power than either of those to grant the relief that the contestant seeks here. So all of this is to say that the contestants have not put before you, have not alleged claims sufficient to state a claim. They're barred by latches, and even in considered on the merits, they fail to carry the contestants' heavy burden of proof. So I'd like to just, and I'll try and be as succinct as I can, address each of those points. First, latches. Mr. Woods, in fact, brought a claim relating to the CTCL grants prior to the election. He brought a TRO motion and lost it. If he wanted to pursue that claim, that's the time he should have brought it. He should have continued to pursue the claim that he in fact brought prior to the election, but he didn't. Instead, he walked away and dismissed the case.
Mr. Hamilton, may I interrupt you? With regard to the latches case or the latches claim, I've only read the Court of Appeals decision. I don't know what the lower court found as far as the latches claim is concerned. Did that get decided?
Are you speaking about the Linwood case that went to the 11th Circuit?
Yes, latches with regard to the settlement agreement.
Yes, the district court judge granted dismissal on the grounds of latches. That's the reason why the 11th Circuit was reviewing the decision and held that it was correct. And that one, Your Honor, so there's two primary components of this election contest case. The first one is challenging the grants. That's the one where Mr. Woods, in fact, brought a claim and then dismissed it. So latches seems obvious there. In the settlement agreement is Your Honor raises that point. That's the Lynn Wood case where the other Mr. Wood brought a challenge over the settlement agreement entered into 9 months ago by the state of Georgia. And what the court held there was if you'd had a problem with that, then you certainly should have raised it at the time. And before the several elections that have been conducted since the entry of that settlement agreement, including the primary election in Georgia, and certainly before the general election in November. And that's exactly what Judge Grimberg wrote. He said, the plaintiff could have and should have filed his constitutional challenge much sooner than he did, and certainly not 2 weeks after the general election. And that's Judge Grimberg's decision in Linwood at page 7. So allowing Mr. Wood to sandbag 5 million Georgian voters by waiting until after they voted and after the votes have been counted and recounted and certified, and then asking this court to reject them all in a judicial wave of the arm is the very definition of prejudice. And so I would submit, Your Honor, they're barred by by latches. As both of these courts have held. And just for the record, the other decision, the one this morning, was in Pearson versus Kemp. That was Judge Batten, who in part dismissed the case on the grounds of latches. And the court in Michigan was in the King versus Whitmer case, federal district court dismissing a claim on latches just this morning. The second reason the claims should be dismissed is they fall outside the scope of Georgia's election contest statute, the one we've been discussing this morning. The court is aware, and we've been discussing, Georgia voters vote for presidential electors. They don't vote for the presidential candidates directly. The election contest statute, which is OCGA 21-2-521, only applies to elections to, quote, federal, state, county, or municipal offices. And the presidential electors at issue here don't fall within any of those categories. They're obviously not municipal or county officials. And because they're appointed pursuant to the United States Constitution, they're not state officers either. And the United States Supreme Court in Ray versus Blair, and we cited that in our briefing, Your Honor, directly held that electors are not federal officers or agents either. So because this election was for presidential elections, it simply falls outside of the scope of Georgia's election contest statute and should be dismissed for that reason as well. So if I might, I'm just going to turn quickly to the actual claims in the contest. Because even if the claims weren't barred by latches, even if they were cognizable, even if they had sued the right defendants, they should be dismissed for failure to state a claim as well. The first claim is a violation of due process. But none of Mr. Wood's allegations even begin to state a claim, much less prove it, that his or anyone else's due process rights were violated. So I'm sure the court's aware to make out a due process claim, a plaintiff must show that they were deprived of a liberty or property interest without notice or an opportunity for a hearing. So let's examine the allegations. First, the receipt of the CTCL grants by several Georgia counties doesn't give rise to a due process violation. Nothing in his contest even attempts to explain this claim or how it might have affected Mr. Woods's property or liberty interests. Second, there's nothing about the settlement agreement or the resulting signature matching process supports a due process claim either. Indeed, if anything, it protects the voting rights of Mr. Wood and all other Georgia voters by ensuring a more careful review of absentee ballot signatures before they're rejected. Mr. Wood has a third sort of claim alleging that election officials failed to enforce voter residency requirements and the prohibition on double voting. But those also don't state a due process claim. Now, in an effort to prove that, Mr. Wood has submitted the expert reports of Mr. Brainerd and Ms. Zhang, and for the reasons in our motion to exclude those reports, those should be disregarded and rejected by the court. I'm just going to touch briefly on the reasons why they don't support the claim. First, Mr. Brainerd is a political operative. He openly disdains science, has no background, experience, or training in statistics, survey, methodology, or quantitative.
This appears to me to be more to the motion to exclude than it is to the motion to dismiss.
I was having the same thought, Mr. Hamilton.
All right. Well, I will simply leave it to the motion to exclude and without repeating it, other than to say the material doesn't support the claim. Voting fraud in the United States is in fact vanishingly rare. Yet Mr. Wood stands before you and boldly alleges the wildly implausible that tens of thousands of Georgia citizens committed felonies by voting twice or voting in Georgia after they moved out of state. You'd think that anyone leveling that sort of powerful charge would have equally powerful evidence, but he doesn't. He doesn't even name them. He doesn't even allege that any of them voted in the presidential election when they cast their ballots, and he can't prove for whom any of those ballots might have been cast. So it's an utter failure of proof if you consider it on the merits, and it's certainly a failure to allege the elements of due process claim. Mr. Woods' second claim is an equal protection claim. And none of these allegations are any more persuasive when presented in the form of an equal protection claim. So I'm sure the court's aware, to prevail on an equal protection claim, a claimant must demonstrate that he or she is being treated differently with respect to a fundamental right or because of a suspect classification, such as race or nationality. If they don't make such an allegation, then the challenged state action will survive an equal protection challenge if it bears a mere rational relationship to a legitimate government interest. So for starters, Mr. Woods doesn't even allege differential treatment with respect to a fundamental right or a suspect classification, and certainly doesn't prove it with any material put before the court. Nothing about the grants suggests that Wood or anyone else was treated differently because of a suspect classification or deprived of a fundamental right. That some counties applied for and received funds hardly establishes an equal protection violation. If anything, the only inference to be drawn is that larger, more populous counties sought and received assistance to help them with the administration of the election. And in any event, this is the same claim that was advanced by Mr. Woods in federal court. And this is the same claim that was rejected there for precisely these same reasons. The same is true of his equal protection claim to the extent that it relates to the settlement agreement. As Judge Grimberg concluded in rejecting that claim in the Linwood federal case, the settlement agreement and resulting signature matching procedures don't establish an equal protection violation because they applied in a uniform manner across the entire state. The contest petition appears to even concede that point, and it's fatal to the claim. And it's not clear whether Mr. Wood bases his equal protection claim on Georgia's alleged failure to enforce voter residency requirements or its prohibition on double voting. That's not differential treatment. The contest doesn't even allege that he or anyone else was treated differently by those failures, and so the claim fails. There's only one last claim in the contest, Your Honor, and that is a violation of the federal elections and electors clauses. Those clauses vest in the legislature of each state the power to regulate the time, place, and manner of holding elections and for the manner of selecting presidential electors. The Supreme Court has held that legislatures can delegate that authority to state officials like the Secretary of State. So the claim can only constitute a plausible violation if the challenged actions exceed the authority granted to the secretary by the Georgia General Assembly. But none of the allegations even come close to meeting that standard. So again, we start with the grant money from the CTCL. There's certainly nothing about accepting grant money that exceeds the authority of state officials. And that's exactly what the federal court found in rejecting the federal court version of this lawsuit. And I quote from the decision: "The elections clause does not on its own provide plaintiffs with a basis to sue Georgia election officials. And even if the elections clause did provide a vehicle to sue, plaintiffs are not likely to show that Georgia election officials' actions would violate the clause, because acceptance of private funds, standing alone, does not impede Georgia's duty to prescribe the time, place, and manner of elections, and plaintiffs cite no authority to the contrary," close quote. Courts around the country have rejected this same claim for that same reason, and I'd submit this court should as well. Second, Your Honor, the settlement agreement and resulting guidance issued by the Secretary provides no more substantial ground for the argument. Judge Grimberg flatly rejected this same claim, noting that the Secretary is the chief elections officer for the state and has the power and authority to manage Georgia's electoral system. Thus, the settlement agreement, he held, was well within the Secretary's authority, and it offers no support for this elections and elector clause argument. Even Mr. Wood appears to admit that nothing about the alleged failure to enforce voter residence or the prohibition on double voting implicates this claim, as he fails to offer either factual support or legal argument on the claim, essentially waiving it before the court. And finally, and probably most fundamentally and most importantly, even if there were a comprehensible claim for violation of the election and electors clause, it's not Mr. Woods' claim to make. He has no standing to bring such a claim. If it exists at all, it belongs to the Georgia General Assembly. And that is exactly what the federal district court in Michigan this morning held in King versus Whitmer, where they held that the election and electors clause claim does not lie for an individual voter or even a slate of electors. So in short, all of the claims fail from start to finish. None of them state a claim for which relief can be granted, and none of them are supported in the record placed before the court to date. And then finally, and I think Your Honor asked this at the very beginning of the hearing, even if the contest petition stated a claim, which it doesn't, even if he had supported the claim with evidence, which he hasn't at least so far, the court isn't empowered to grant him the relief that he seeks, an order nullifying the results of the presidential election or an injunction to the governor prohibiting or decertifying the certification of the presidential electors. That relief would violate federal and state constitutional law with respect to how we select electors. It would violate the constitutional protections of the voters of the state of Georgia. It would violate due process with respect to all of them, and the First Amendment rights of literally millions of Georgia voters. Just this morning, as I mentioned, Judge Batten dismissed the so-called Kraken lawsuit in federal court on a variety of grounds, but specifically found that the remedy there, a do-over election like the remedy here, was not available. The judge in the Michigan case reached the same result, and we urge the court to reach the same result here. Last week, the Third Circuit wrote, "Voters, not lawyers, choose the president. Ballots, not briefs, decide elections." That's not something that a court should have to remind litigants. But since the election 1 month ago, we've seen the same pattern across the country. Baseless lawsuits filed by plaintiffs who simply can't accept the outcome of the election. But that's a choice made by the voters of Georgia, at least with respect to Georgia's 16 electoral college votes. And it's a choice that can only be reversed or thrown out by this court on the most powerful of showings and with clear and convincing evidence of widespread fraud or error. Breathtaking relief requires breathtaking evidence. But Mr. Wood fails to even make actionable allegations, much less proffer the court with anything that would support that claim. So none of this is sufficient. None of it states a claim for which, upon which relief can be granted. It's barred by latches. It's outside the scope of the elections contest, and it fails to name the appropriate defendants. Your Honor, I mentioned earlier the safe harbor deadline. It is important to provide certainty and clarity to the voters, not only in Georgia, but across the country, and remove any question or uncertainty around this. And I would urge the court to enter a final judgment prior to the expiration of the federal safe harbor deadline, which is tomorrow.
Thank you,
Thank
sir.
you.
Thank you. Mr. Hamilton. Mr. Harding.
Yes, Your Honor. With regard to filing, Georgia law requires this to be filed within 5 days of certification. We made that deadline. 21-2-522-3 says you can bring an action, a grounds for contest. Number 3, when illegal votes have been received or legal votes rejected at the polls sufficient to change or place the results in doubt. We allege there was about 150,000 illegal votes. People who voted outside of residency, a little over 20,000 who voted out of state. I believe it was 395 who double voted. Those are all illegal votes under Georgia law. With regard to stating a claim, as I know the courts, sorry.
Question, Mr. Harding, are those numbers from the Baynard or Brainerd material?
Yes.
Yes, Your Honor. Yes, Your Honor. If I may jump in, if that's all right.
So those are, and let me just clarify my question a little bit for either one of you. Those are numbers. Extrapolated is going to sound a little charged, but those are numbers that are taken from samplings.
Yes, Your Honor. So some numbers, we're starting with the government data. So I appreciate Mr. Hamilton's argument, but our claims didn't involve fraud. I mean, Mr. Wood didn't oversell this case, didn't overstate it. The concern here is that the government data available after the election and Mr. Hamilton saying that somehow this is politically charged, but it's government data. So with respect to things like double votes, when you have a person's name, address, and year of birth, you can pretty much identify people. And so double votes are something, that raised an interesting question. Should Georgia election officials be certifying a result, including double votes, when that can be verified in the government data? And then we can go to the other categories.
But my question was simply the numbers that Mr. Harding referred to were numbers from, and I apologize for I want to get the name right, are numbers from the Brainerd affidavit.
Correct. The list that's in the petition, that's on page 3. So if we could go to page 3, that might be helpful.
Okay, because the reason that I'm asking is simply because I read every single solitary affidavit by a voter. And in each of those instances, unless I'm mistaken, and please tell me, because I could be, but I read each and every one of those affidavits. Those were people who voted, and there appeared to be 2 main claims. One, somebody gets to the polls, hands their ID to the poll worker. The poll worker said, "Hey, you already voted." That person was then allowed to fill out a provisional vote, and in most cases, I think, confirmed that provisional vote was granted. The second instance detailed in those affidavits was voter gets to the poll, hands the poll worker their ID. Poll worker says, wait a minute, you requested an absentee ballot. Person says, I never requested an absentee ballot, and they were sent over to provisionally vote or to vote on a provisional ballot. Their provisional ballot in, I think, almost all cases, maybe one said, well, I didn't check, but those provisional ballots were accepted. So the premise that there were double votes, there's no one who has submitted an app. Here's my question, and I don't mean to be obtuse, but here's my question. There are no affidavits that say I voted and somebody else voted using my name, or I voted and somebody else voted on an absentee ballot that I didn't ask for. Are there any affidavits before me that say those latter two things?
The answer, no, as to those two questions.
Okay.
Yeah, we do have the category absentee ballot unreturned. And there, the phone calls were made to people who in the government data were noted as absentee ballot unreturned. And then in that category, and I don't remember the percentage, but the percentage of those people said they had voted absentee.
33.
And then that number by Dr. Zhang has been extrapolated to be 43,688. So under the Georgia standards for election contest, would that put the election result in doubt? And it may be a question of first impression for the court, but Mr. Hamilton is absolutely incorrect that a Georgia citizen can't come into court and say, look, Judge, there are a lot of people here, these are recorded interviews, who said they submitted an absentee ballot, and then the government's recorded absentee ballot unreturned. I mean, that's a fair question.
But is there any such person? That was my question.
Yeah, we have recorded interviews regarding those phone calls with respect to the survey, and that could be submitted to the court. Those are people. I didn't think your question. I didn't think your question when you posed it said, "Did someone cast a ballot and not have it counted?" That I was talking about the specific category.
Again, my question went to your affidavits, the things that are in the record. Your sworn
Right.
affidavits.
Right, and this one's in the record. The legal votes not counted.
That's in the record via the Brainerd affidavit and extrapolation of numbers, is it not?
By Dr. Zhang, right?
Okay. Okay.
Yeah, that's a good example. But the point is that there's questions here, and the questions arise from the government data, and the government data shows that the absentee ballot system. Let's just start with the point. It's not perfect. Okay, well, we don't expect the human system to be perfect, but we do expect the government data to reflect that the election result is not in doubt. And so we collected the government data. Brainerd looked at it. Mr. Hamilton, he could have his people look at it. And with respect to, and maybe the extrapolations are different, but at least with respect to the tabulations, they're going to be the same. So it's roughly going to be, for double votes, 395, whoever looks at it. I mean, if the court were to grab it, there'd be 395 people that could indicate they double voted. With respect to out-of-state residents voting in Georgia, which include some double voting, 20,312. Some of those registered outside Georgia and voted as well. Those would be the double voters. So, this is the type of data that would cast a close election result in doubt. And Mr. Hamilton is very good at suggesting that in Georgia, you need to show fraud and have evidence of fraud and all of that. Well, in Georgia, the standards say, are there legal votes not counted, illegal votes counted, which would cast doubt on the election result. Now, I know there are some technical issues that have been raised here regarding latches, But it does take some time to get the government data, and it takes time to evaluate election official conduct and to see if legal votes have not been counted, illegal votes counted. So so what you do is you get the data after the election, and then you look. Now, if there's nothing there, as Mr. Hamilton suggests, then we wouldn't be here. But when you look and you see, oh my, Georgia's absentee ballot system isn't as tight as it ought to be. Mr. Wood says, well, wait a minute. We called people and it said absentee ballot unreturned, but they told us they voted. We looked at where people resided, and apparently we have a big problem with identifying voters, residents, because they're not voting where they reside, or maybe it doesn't match. It doesn't verify the election result. With respect to out-of-state residents voting in Georgia, they alone exceed the election margin. And then you have the double votes, which I can't understand any system where the Secretary of State or the governor would certify a number with double votes in there when the government data is available to take out the double votes. So it may very well be, Your Honor, that with respect to this deadline that's coming up, with respect to some of these, the expedited nature that this has to occur, that there won't be a remedy. But I want to talk about that in a second. But the point is that the concern here is, let's have the best election system we can in Georgia. And when the statute allows an election contest in this way, then in a close election, I mean, it's pretty clear that we don't know who won. Now, we have a system that counts the votes, and in that way, the Biden electors won. But when you have error that can be shown through government data, it has to cause one to pause and say, okay, we know there are going to be some errors or mistakes in absentee balloting systems, but is this acceptable? I mean, it's so high, Your Honor, that it causes one to pause and say, well, maybe we should take a look at it. What about these 20,000 out-of-state residents voting in Georgia? If that's true, well, then there's a doubt on the election result. Now, I understand that the remedy is a challenging one, but the point is that we need to do better with respect to these election official absentee ballot rate errors. Now, with respect to the deadline tomorrow, it's a federal statute in Title III. It's called Safe Harbor, but that relates to the remedy. And I think Mr. Hamilton would agree that the remedy is threatened by that. But with respect to the election contest, and that is, what were the actual count? What was the result in Georgia? That's at issue here. And there's something higher than a federal statute, like Mr. Hamilton is suggesting, and that is, there's a right to a full trial, a right to a trial in this proceeding. And I don't think that Mr. Hamilton relying on that statute means that there can't be a trial in this proceeding, because that is a right that one has in this election contest, and that is to have a trial, and that's a due process right, and that should proceed. So I don't think the safe harbor prevents this matter from proceeding. I think on latches, we've addressed that. I also wanted to mention there have been a lot of form issues raised by the governor and the Secretary of State regarding the contest itself. And it's very important to understand that Georgia is very generous with respect to election contests. The standard is generous. The scope is generous. The state legislature intended for these things to sort of be aired out. Now, I understand this idea that it's a grave remedy to set aside an election. But as far as discussing after an election in the context of election contest and adjudicating those claims regarding election official irregularities, I think that's pretty normal, and that's what's intended. But I did want to mention in the subsection E of Section 8, and the petition reflects this section very specifically. particularly the one mentioning what has to be alleged in the petition. But in E, it says, a statement of the grounds of contest shall not be rejected, nor the proceedings dismissed by any court for want of form, if the grounds of contest are alleged with such certainty as will advise the defendant of the particular proceeding or cause which the primary or election is contested. So the idea is for the court to take the citizen complaints and to address them. And maybe, there's equitable relief, maybe there's some other form of relief, but really what's required here is getting to the bottom of why there was such an absentee ballot error rate. I mean, for pre-election with respect to certification of voting systems under HAVA, the error rate is 0.0008%. And here, based on the government data, and let's just say Mr. Hamilton's right and, take off, half, right? Whatever, you're down to 100,000 or 50,000. Well, under the HAVA rate pre-election, there should be about 50 ballots that aren't counted. Well, illegal, 50 ballots in error, not 10,000, not 50,000. So if we're going to certify close elections, we want to make sure that we have the best system possible. So I think that the motion to dismiss should be denied. I don't think that the latches or the safe harbor are a concern. It may affect the remedy that Mr. Hamilton's concerned about. But with respect to getting elections right, I think Mr. Hamilton and I would agree that we want illegal votes not counted and all legal votes counted. And there are serious issues here that need to be investigated. And that's what we're looking to the court to give us a chance to investigate and have a hearing. Thank you.
Okay, Mr. Cardall, this may be a fool's errand to ask you questions about something you know a whole lot more about than I do. But I just, whether it forms the basis of the court's ultimate decision or not, I do think it's important, since you have alleged that the government data shows certain things. I just want to make sure, and again, whether it forms the basis of my decision or not, I want to make sure I understand what you're saying, because I think that the numbers that you're talking about primarily, I think, are the numbers that come out in the Brainerd affidavit. And that is based on 722 telephone calls that his organization made and the responses given by those people. And specifically, I'm referring to pages 7 and 8 of his affidavit or his opinion. From there through, I don't know, I think it's algebra. From there through, again, I'll use your word this time, extrapolation, we get to these figures of 20,000, 100,000. Is that true or not?
That's true in the first two rows, Your Honor. And I'm sorry, I must be doing a poor job of communicating. But yeah, there were two, and Zhang did two extrapolations, but not with respect to the residency violations or out of state. That's just a matter of the computer, the data from the government.
And that's just that's a comparison of votes to the change of address database.
That's right. They're violations, right?
Okay, and that gets into a whole nother. Okay, all right. Thank you. I appreciate that.
And thank you for giving me the time, Your Honor. Thank you.
Okay. Anything further, Mr. Harding?
I think he summed it up for us, Your Honor.
Okay. All right. Well, let me just say this before we go on, because I think the next thing that we would be saying, that we would be talking about, is the issue of the Brainerd affidavit. But let me just ask one question of Mr. Willard. So are you still on? Yeah. Hey, Ms. Willard.
Yes, Your Honor.
So there is the governor and the Secretary of State would have immunity as to general issues of injunctive relief, such as here.
Correct. Any sort of equitable compulsion or prohibition against them in their office.
Because we're clearly not talking about mandamus here, because these are not,
Correct.
these are functions that, not, I won't say discretionary, but we're not talking about mandamus.
Well, and mandamus wouldn't be appropriate anyway, Your Honor, because as Your Honor is aware, mandamus cannot be used to compel the undoing of a completed act. And
Okay.
at this point, and you didn't provide me the opportunity, Your Honor, to address any of the arguments related to the intervener's motion to dismiss, which is fine. There are a couple of points that Mr. Cardall raised in his argument that I wanted to address if I could briefly. First, I believe the interveners are correct that laches bars any claims regarding the grants that were received by Fulton County. Not only are there no proper parties before the court today to delve into whether Fulton County acted appropriately, but Mr. Wood was a plaintiff in that litigation in front of Judge May. He got an adverse ruling. He failed to pursue the matter, and those claims should be barred. Likewise, Judge Grimberg had a very exhaustive analysis after we had made our arguments in federal court in the Linwood case as to why the plaintiffs in that, or the plaintiff in that case, had basically sat on his hands for the 9 intervening months and not taken advantage of any of the mechanisms that he could have to have challenged either the settlement agreement or the promulgated rule by the state election board. Finally, in terms of the presidential electors and where we find ourselves now, Mr. Cardall made 2 inaccurate statements that I think for the record need to be resolved. First, he said that, quote, "we don't know who won." For purposes of Georgia election law, we do know who won. The Secretary of State has certified the election results received from the counties. The governor has certified the slate of presidential electors who will meet when the Electoral College meets. Absent some intervening ruling that reverses that, the state of Georgia knows who won the presidential election in Georgia, and the mechanisms for carrying that to fruition are proceeding apace. Finally, he also says that the, quote, "scope is generous in Georgia as to election challenges." Per our argument today, that is a false statement. Georgia specifically sets out who can bring election challenges and who they can bring them against. As my argument demonstrated to the court earlier, that scope is very narrow, and the governor and the Secretary of State do not fit within that scope. He also appears to be saying that even despite the fact that his relief will be moot, he's asking for a trial on the merits. He's asking for an advisory opinion from this court after any ability to gain meaningful relief has passed. That at that point, Your Honor, there will be case or controversy pending before this court. And as this court is aware, it is not within the judicial power and judicial authority to enter advisory opinions about things that have already occurred. With all that being said, we believe that this case should not move forward. The slate of electors has been certified by the governor, and they do not have proper parties before you that would allow you to reverse that.
Anybody have anything else to say before we move on to the motion to strike the affidavit?
Yes, Your Honor, if I might be heard just briefly in rebuttal in reply to the argument. I'll just make a couple of points. Number one, Mr. Harding, counsel argued that this is government data and he's simply matching name, address, date of birth in order to determine double votes, as I think we're going to talk about with respect to the experts. That is an error-prone analysis, and he provides no evidence, no discussion whatsoever. So it's notoriously faulty methodology. Number two, he referenced telephonic interviews that could be submitted to the court at some future date. That is the very definition of hearsay, an out-of-court statement off for the truth of the matter asserted. And it would be patently inadmissible even if brought in. Number three, all he argues with respect to out-of-state residents voting is that they filed a change of address form. But people do that all the time, to serve in the military, to attend college, to take care of aging parents, to seek medical treatment. You don't lose your Georgia residency simply by moving out of state in many instances. And since he can't control for that, the data is utterly meaningless. And then finally, I'll just note what he didn't address. He didn't discuss the equal protection claim, the due process claim, the electoral elections, and like the very claims that bring him before you today. He didn't discuss why the grant argument isn't barred by the statute of limitations, much less the settlement agreement argument. And I think there's a good reason that he didn't address it. I wouldn't have either if I were him, because I wouldn't have brought the claims to begin with. So for all those reasons, Your Honor, we think the motion to dismiss should be granted.
Okay, up until this point, I've taken everything under advisement because I wanted to hear what you had to say. And I'd also like to point out that everyone's under a good bit of pressure here. Mr. Harding obviously has undertaken his work within a short period of time. The interveners have undertaken their work within a very short period of time. And the defendants, the respondents in this case, were just served. So I first of all want to thank Mr. Willard for appearing, and his appearance not only is meaningful under the fact that he came and showed up and made an argument, but also that it allows this court to move within a certain period of time. And I am going to do so. I'm granting the respondent's motion to dismiss. And all motions to intervene and other motions are thereby moot. In granting the respondent's motion to dismiss, I do want to point first of all to just the substance of the argument itself. Secondly, no one really objected to the fact that this was an oral motion and that it was made on the day of the hearing. And I think the reason for that, again, as I've stated, is that you're all acting in I think under extraordinary circumstances, and I think you're doing extraordinary jobs. So I do grant the respondent's motion to dismiss, both on the fact that, as Mr. Willard stated, there's not a statutory basis for these named individuals being respondents in this case, and for any other reason. And the motions to intervene are therefore moot, and all other motions are therefore moot. Who is going to submit an order?
Your Honor, we can submit a proposed order to that effect.
Okay, I would appreciate that. And again, I appreciate everybody's appearance today. Again, I know that everybody is operating probably, well, under very short time periods and probably without a lot of sleep or weekends. So I'd like to wish you all happy holidays. Thank you very much for appearing in this court. You're all welcome back at any time. And with that, I'll excuse everyone.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.